Trash the bags and keep our recycling program moving forward.
No, Mom, look, no plastic bags.
Do your part to keep our recycling bag-free. Trash the tanglers or return them to participating retailers. For more information, visit tampabayrecycles.org.
Good evening. If you could please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good evening, everyone. I want to welcome you to the June 17th, 2019 Zoning Hearing, Master Hearing. My name is Susan Finch, and I'll be presiding over the majority of the cases for tonight's agenda. The first two cases, however, will be heard by Hearing Master James Scarola, who is seated to my right, and he will handle those two first cases, and then we will get back to the regular agenda. The agenda, with the exception of Hearing Master Scarola's cases, begins with the special use applications. But before I've jumped ahead, let me introduce, Mr. Brian Grady from the Development Services Department, who will introduce the other members sitting at the dais of tonight's hearing and also go over any changes to the agenda. Mr. Grady.
Thank you, Ms. Finch. Again, for the record, Brian Grady, Hillsborough County Development Services. Before I go through with any changes to the agenda and published withdrawals and continuances, joining us at the dais tonight are to my left, Mr. Lewis Whitehead with the County Attorney's Office. To his left, Melissa Leinhard with the Hillsborough County City County Planning Commission. And to her left, Tom Hisney with Development Services. Tom will be handling the special use applications on tonight's agenda. We have no changes to the published agenda, so I'll go through the published withdrawals and continuances beginning on page 5 of the agenda. First item is item A1, rezoning application 19-0017. This application has been withdrawn from the zoning hearing master process. Item A2, rezoning application 19-0554. This application is being withdrawn from the zoning hearing master process. Item A3, major mod application 19-0669. This application is being withdrawn from the zoning hearing master process. Item A4, rezoning application 18-0798. This application out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A5, rezoning application 19-0102. This application is being continued by the applicant to the July 29th zoning hearing master hearing. Item A6, rezoning application 19-0282. This application has been continued by the applicant to the July 29th zoning hearing master hearing. Item A7, rezoning application 19-0284. This application has been continued by the applicant to the July 29th zoning hearing master hearing. Item A8, rezoning special use application 19-0305. This application has been continued by staff to the July 29th zoning hearing master hearing. Item A9, rezoning application 19-0310. This application has been continued by the applicant to the July 29th zoning hearing master hearing. Item A10, rezoning application 19-0409. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A11, rezoning application 19-0432. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A12, major mod application 19-0521. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A13, rezoning application 19-0535. This application is being continued by the applicant to the July 29th zoning hearing master hearing. Item A14, major mod application 19-0546. This application has been continued by the applicant to the July 29th zoning hearing master hearing. Item A15, rezoning application 19-0655. This application is being continued by staff to the July 29th zoning hearing master hearing. Item A16, rezoning application 19-0730. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A17, rezoning application 19-0745. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A18, rezoning application 19-0748. This application is out of order to be heard and is being continued to the July 29th zoning hearing master hearing. Item A19, rezoning application 19-0793. This application has been continued by the applicant to the July 29th zoning hearing master hearing. Item A20, rezoning application 19-0404. This application is out of order to be heard and is being continued to the August 19th zoning hearing master hearing. And item A21, special use application 19-0220. This application is out of order to be heard and is being continued to the September 16th zoning hearing master hearing. That concludes all withdrawals and continuances.
All right, thank you so much, Mr. Grady. Let me start again and tell you, with the exception of Hearing Master Scarola's two first agenda items, which are remands back from the Board of County Commissioners hearings, the items begin with the special use applications, and those are applications that we will hear as the zoning hearing master and make a decision on each of those items within 15 business days following tonight's hearing. The remainder of the items require a public hearing before a zoning hearing master, and we file a recommendation within 15 business days following tonight's hearing. That recommendation goes to the Board of County Commissioners, who make the final decision. Our hearing tonight is informal. I'll ask questions related to the direct testimony presented tonight, I'll call and question witnesses as I deem appropriate and necessary, and will decide all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of the evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation tonight is as follows. Mr. Grady, or in the case of the special use applications, Mr. Hisney, will provide a brief introduction of each agenda item. And then we will call for the applicant. The applicant and their team have 15 minutes total to present their case. We'll then go back to the development services staff member who was assigned the case, the planner who was assigned the case, and they will have 5 minutes to go over the county's findings. Then, if applicable, the Planning Commission also will have 5 minutes next to present their findings in terms of the application's consistency with the comprehensive plan. We'll then call for proponents, anyone who would like to speak in favor of the application. Total proponent time, everyone included, is 15 minutes. Same is true when we turn to opponents, anyone who would like to oppose an application. Everyone total has 15 minutes to present their testimony. Finally, we'll go back to county staff who has 5 minutes to address any issues, items, change recommendations, and so forth. And then the last word will be had by the applicant who has 5 minutes for rebuttal to address any issues that were brought up. The 15 minutes total for both proponents and opponents. If you want to designate a speaker and use your time more effectively, that's fine. If you don't have a central speaker, then I'll ask for a show of hands as to who would like to speak. We'll count and we will divide the time by the 15 minutes equally as best we can. When you come up to the podium, if you could, this is a microphone up at the podium where you'll speak. Make sure you are speaking clearly into it and start by giving us your name and address for the record. We are recording this proceeding and we want to make sure we have it accurate. If you have to leave and then come back up and say something, just make sure you also start by giving us your name so that we can tell from the transcript who is speaking. When you're done, if you could see Allison at the end of the dais, raise your hand, Allison. She is with the clerk's office, and we would ask that you see her to sign in with your name and address just to make sure we have the spelling correct. So with that, because we are going to start with 2 zoning matters, I'll ask Mr. Whitehead of the County Attorney's Office to explain the legal requirements for oral argument that govern your participation at the Board of County Commissioners meeting. Mr. Whitehead.
Thank you, Madam Hearing Officer. As stated, the hearing officer will file a recommendation for rezoning applications on July the 9th. After the recommendations have been filed, each individual who desires to address the board at the public meeting must file an oral argument request no later than the close of business on July the 19th. These petitions are scheduled to be heard by the board at the board's August 13th land use meeting. Oral argument request forms are available on the table located at the entrance to this auditorium. Please note that oral argument requests must be responsive to the hearing master's recommendation. Accordingly, oral argument requests should not be filed until the hearing master's recommendations have been delivered to the county on July the 19th. On July the 9th. The board is not required to hear oral argument at the public meeting. However, under certain circumstances, the board can elect to hear oral argument from a party of record. A party of record is an individual who fits into at least one of 4 categories set forth in Section 10.3.6 of the Land Development Code. In the event that the board elects to hear oral argument, parties of record who have filed responsive timely requests will be considered for oral argument. Oral argument requests should clearly indicate why oral argument is necessary to address at least one of 4 outstanding issues set forth in Section 10.3.4E of the Land Development Code. Scope of oral argument shall be limited to the content of the testimony and other evidence submitted verbally or in writing to the hearing master tonight. The board will consider only the record of tonight's hearing and the recommendation of the hearing master in its decision. The county attorney's role is to ensure that only individuals who have met the party of record requirements are allowed to address the board at the public meeting. Thank you very much.
Thank you, Mr. Whitehead. I appreciate it. As I mentioned, all testimony must be under oath. So if you plan to speak tonight, if you could please stand, raise your right hand, and I'll swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. All right, at this point, let me turn the hearing over to Hearing Master Scarola, who will call the first two items.
Brian, our first petition.
The first item is agenda item B1, rezoning application 18-1048. The applicant is Indian Ridge Ranch Incorporated. The request is to rezone from AR and AS1 to a planned development. I will provide staff recommendations after presentation by the applicant.
Good evening.
Good evening, Mr. Hearing Master. My name is John Grandoff, and I practice at the Hill Ward and Henderson firm, and I'm joined this evening by my law partner, Gina Grimes, who's passing out our binder of evidence. I'm also joined by Mr. Tim Powell and Mr. David Wright of the TSP companies, our planning consultants on the project. And finally, our client, Mr. Wayne Davis of Indian Ridge Ranch, is with me this evening. If you will all raise your hands, please.
You can do it now.
Preliminarily, I would ask that we be allotted some more time in our presentation. The reason being this matter was remanded from the Board of County Commissioners back to your jurisdiction. And after the remand, a finding of inconsistency was filed by both agencies, the Planning Commission and the county planning staff. And thereafter, the recommendations were changed once again to now findings of consistency and compatibility. So we've done almost a 360 degree loop, and that has required a significant binder of information to provide to you.
Well, that was good work, and as you know, I'm capable of reading the information. They've got a big agenda tonight.
Okay.
And so, I mean, how much time do you think you need? I understand it's a complicated petition, but 5 extra minutes?
5 extra, and maybe we take it on rebuttal, if that would be
That would be a good way to do it.
let's do this. Why don't I reserve 5 extra minutes at rebuttal if I need it?
That's fine.
Okay.
Yeah,
Thank
thank
you.
you.
We'll proceed. You're familiar with the project and the location, and what I'd like to do at this time is your report of February 12. I ask that you incorporate by reference that report and all of the evidence that was filed in the making of that report. So that will shortcut a lot of your deliberations this evening, so we can focus solely on the issue of remand.
I typically use the report and add to it.
Okay, thank you. The purpose of the remand was to address specifically Comprehensive Plan Policy 48.1, which is located on page 4 of the Planning Commission's report. And I'll summarize it, and it states that the Wimauma Village residential land use category shall be dependent upon the extent to which developments are planned to achieve on-site clustering, which we do, and in order to achieve densities in excess of 1 unit per 5 gross acres, the Wimauma category developments shall achieve minimum clustering ratios, job opportunity provisions, and shopping provisions. These are 2 important concepts that will come up this evening, as required by this plan, except as noted in the zoning exception found in the implementation section. In summary, we had a dispute over whether jobs are required before rooftops or rooftops are required before jobs. And we submit to you that while we had a disagreement with the Planning Commission on the interpretation of 48.1, we nonetheless have arrived at the same point of agreement, and that we meet this requirement, and that the 48.1 is a future tense requirement, and that we will provide the homes before the jobs, and the jobs, in fact, are there in the Wimauma community, as will be shown in our evidence this evening.
Does that mean that it's a transitionary problem where you accumulate jobs as the rooftops come in, or does it mean that the jobs are there so the rooftops can go?
Both. You have jobs there, and then you're accumulating more jobs as the project is becoming built out.
And you're monitoring that?
And we're monitoring that. In fact,
Yeah.
the Planning Commission and the county staff monitors that,
Yeah.
as noted in their reports. So to go through our binder of evidence, if you'll turn to tab 1 on the 5th page, Tim Powell, an expert in the field, at the top he noted there are no employment requirements anywhere in Objective 48 that states that PD rezoning in the WVR2 plan category provides jobs at the time of rezoning. Tim continues, and he makes a finding on his 6th page about the bottom. The WVR employment and shopping requirements shall be tracked through each plan development district as part of the county's annual plan development review, addressing the question that you just asked me, which translates to me that the employment and shopping requirements are meant to be complied with in the future. Tab 2, the Planning Commission report. Besides Policy 48.1, on page 8 of the report, 3rd line from the bottom, Planning Commission staff finds in summary that the Wimauma Village requires employment and services to exist to support the residential development. With the current commercial entitlements within the village, there's adequate commercial entitlements to meet the 75% threshold of the needed housing services to support the number of residential units. 75% of the needed household services equates to 28,000 square feet of commercial. There's currently a total of 80,000 square feet of commercial contained within the Wimauma Village. The conclusion
I'm sorry, 80,000.
80,000.
Right.
This adequately supports this development as well as prior approvals. So 2 different methods, we reach the same result as demonstrated later in this binder. On tab 3, getting into Mr. Grady's staff report, section 1.7, no objections from any of the staff. And the project is approvable subject to conditions. At this juncture, I want you to go into Mr. Grady's report on the agency review comment sheet. It is revised by Mr. James Ratliff. As of June 6 of 19, you'll see on the top right-hand corner of his
Is this part of the staff report?
It's going to be in the back of the staff report. Unfortunately, it's not numbered, but I numbered it. And if you go to the 7th page of the agency review comment sheet by Mr. Ratliff, you'll pause for a moment while he locates that.
Okay, I'm at the Ratliff comment sheet, and go to page 7 of that.
The 7th page, yes.
Okay,
You see where it says information for remand?
I do.
Okay, he was instructed by the county commission at the time to relook at the transportation. He did that. So besides incorporating for reference your prior report, I'd like you to review his information as supplementary to that report. Going to tab 4, Mr. Wright, one of our consultants, prepared a Wimauma Village Employment Opportunities Analysis, which is a tab 4A. And you'll note at the bottom of his study, which was discussed with the Planning Commission staff, there's a surplus of existing jobs. You also have tab B.
That's 684?
Yes, correct. And you can find the sub-calculations above that.
I don't want to dig in too deep, but I want a general feel for this. That surplus of existing jobs, so that's jobs today when weighed against the A through E projects?
Right, you have Wimauma Village existing jobs total, 2,112. Subtract those 2 rezoning projects, and you still have a surplus of 684.
Okay, and in this analysis, the Indian Ridge Ranch project
Right,
is not yet included.
right. The categories A through E are where the jobs are coming from.
Right. Okay.
I'm going to skip over tab 5 and go to tab 6. Briefly, you'll find Lorraine Duffy Suarez made a finding that the school site is supported by provisions of the public school facilities element. Continuing tab 7.
Was that a question for remand?
No, but I want to point it out. It's important to know that that's supported. Skipping to tab 8, 8A, an issue has come up as to whether 48.1 was vague. I've prepared a memorandum of law that shows that if there is vagueness in a comprehensive plan language, you may look outside the four corners of the document and take evidence of the framers of that plan to determine what was the intent. We have the framers of that plan here this evening who will speak to you, among them Mr. Wayne Davis. And you can see my memorandum, which justifies our position on that.
What is a framer of the plan?
Someone who was present at the time the plan was written, the Waimama plan, and had a stake in the project and helped craft that language. Tab 8B, Mr. Patrick Davis provided to you some background on what was the intent of the plan. We have a professional opinion, excuse me, from Brian Wester, an independent planner. His finding on the last page: it is my professional opinion that any condition, development agreement, or mitigation requirement for a PD in the Waimama Village to provide commercial or employment in said PD or off-site from the PD in the downtown village has no rational nexus that can be substantiated by the comprehensive plan or the LDC. I ask you to review Mr. Wester's opinion in further detail and his curriculum vitae.
Which tab is that?
That's going to be, if you hold the time for a moment, in tab 8C.
C. Okay.
On the DMHD letterhead.
All right.
And in summary, the remaining tabs after tab B, which include tab A, B, C, D, and E, are letters of support and interpretation from stakeholders in the Waimama plan. Essentially, the Waimama property owners made a bargain with the county to adopt the Waimama plan, and we specifically find that that bargain has been met, and we request your recommendation for approval. At this time, I'd like to pause for a moment, and I have the distinct pleasure of introducing our client, Mr. Wayne Davis, who has, his family's been involved in Waimama for many, many years. They were involved in the plan, and I'd like him to explain to you what was meant by the intent of the plan. Mr. Davis, please come forward.
Good evening, Mr. Skrilla.
Good evening.
I last spoke with you regarding Waimama on January 22nd. I'll be as brief as possible, but it is important to review some history of Waimama. Oddly enough, Waimama at one point in time was the commercial center of South Hillsborough County. Not many folks would recognize that today, given that other South Hillsborough communities have grown much faster. It was a very active agricultural and sawmill milling town, and it was very viable all the way up to the Depression. In fact, in 1925, Waimama was incorporated as one of the 3 cities in Hillsborough County. It later lost that in the Depression. During the 40s and 50s, it had a very hard time recovering from the Depression. My family was a part of South Hillsborough County during all of those time periods. My family came there about 112 years ago. Waimama is about 124 years old, which oddly enough is about half the time that the USA has existed. And that's a fact that not many folks would take notice of, but I have. And during the course of its history, we found that Waimama really tried to recover and did up until about the late 60s or early 70s, when we saw a dramatic downturn in the economic viability of town. With that, we saw an increase in crime and undesirable elements come into the town. Oddly enough, in the late 90s, going into the early 2000s, the state and the county mandated that we do community plans. At first we thought, my, what a big chore for not much. As it turned out, the community plans are a really good thing, and they were a really good thing for us because it gave us an opportunity to analyze what the real problems in Wimauma were. And one of the things we really honed in on was that it was economically depressed and it really needed help. Most of the big parcels of land in Wimauma had an RP2 land use designation, which would have required that commercial be included in every development that occurred over time. When we looked at that, we thought, my, this is really going to be negative for downtown Wimauma. And how do we amend that so that we support the downtown Wimauma area and not detract from it?
So you were concerned about disaggregating the commercial?
Yes,
into the
and trying
developments,
to be sure that the surrounding development of residential supported downtown and it wasn't fragmented over 5 or 6 developments. And you just see downtown finish withering and die. I'm sorry if I go over time. Could I have just a couple minutes?
Sure.
Okay. And so in the process of developing the Wimauma Community Plan, and we ranked all of the important items to go into that plan, the chief item that we honed in on was economic viability. And with that, we made an agreement as landholders that we should have a new land use that would move all the business and employment to downtown, other than folks working at home, and have residential separated from downtown. And with that, we developed the WVR2 land use category, which is what we have today. And that enables us to develop surrounding downtown Wimauma and bring all the economic viability back to town that comes with a large number of new residents.
Was this already expressed to the Board of County Commissioners at the last board hearing?
It was through my comments to you, but to be quite truthful, we've never been allowed to speak to the Board of County Commissioners, which seemed a bit unfair. But that was the process. So with that, all the people who own large tracts of land around Wimauma said, we want to help. And you have support letters from the councils and some other families that are long-standing members of the community saying, we agreed to help. We really wanted to. Now don't try to bar us from helping when the time has come. So with that, I'll answer any questions that you may have or anyone else has. But if there aren't any questions, I would ask for your approval of our project so that we can create a community that does exactly what we set out to do in that community plan.
Appreciate the history, Mr. Davis.
Thank you.
Okay. All right, and development services.
Brian Grady, Hillsborough County Development Services. The subject property is 520 acres in size and currently zoned agricultural rural. Their applicant is seeking to allow a predominantly residential project in compliance with the Wimauma Village Plan. The project will allow a maximum of 1,056 single-family detached lots, a possible public school tract, and a residential sport use tract. As outlined in the staff's report, the project is provided the necessary elements called for in the plan. This includes clustering lots at a minimum ratio of 3.5, a mixture of uses within the project, a connected street network, connected open spaces, and a housing product that will provide for a variety of options to the graded community in an ungated subdivision. The project will provide access points at Bishop Road and County Road 579 with numerous cross-access points along all perimeters. Transportation staff will review the application and has no objections subject to conditions. The project has been approved for 3 design exceptions for both County Road 579 and Bishop Road, which are included in the staff report in Exhibit 5. The applicant has worked with the Planning Commission staff to analyze the project's compliance with the requirements for employment and shopping to be in the area to sustain the development in accordance with the referenced policies in the comprehensive plan. The Planning Commission has found the project meets this requirement. Attachment A and B within the conditions outlines that information to demonstrate the calculations to compliance with those requirements. Based on these considerations, staff does recommend their approval. We do have changes to the staff report. One is to correct a typo in section 1.5. Inadvertently, the discussion indicated that the Planning Commission did not find the project consistent with our Waimama Village plan. It said does not, and so we're moving the not to say that it does meet the Waimama Village Community Plan. We're also modifying condition 7 that deals with the tracking of the employment and shopping requirements. There was an incorrect reference to the wrong objective. It's objective 48. The condition said objective 28. And then we're also simplifying the language to make it clear that the purpose of this condition is to provide for the tracking of that information within the plan development as required by objective 48 of the comprehensive plan. No other changes to the report, and available if you have any questions.
In short, if you were to summarize this remand request, it was centered around the employment issues and the transportation design exception issues. Is that fair enough to say?
It was centered, but as part of the remand, the commissioner making the remand motion did also make reference to the details in the plan. You will note that the applicant did amend the plan and provide some more details regarding the internal circulation and the open space. So I think obviously the consistency with the employment and shopping was the major issue, as well as the transportation, but there's other issues. But the applicant did address those as also as part of their revised submittal for this remand.
Thank you, Brian. And the Planning Commission.
Thank you. Melissa Leinhard, Planning Commission staff. The subject property is located in the Waimama Village Residential 2 Future Land Use category. It is in the rural area and is within the limits of the Waimama Village Community Plan. This case was remanded to consider the employment and service requirements as contemplated by the Waimama Village Residential 2 policies within the future land use element and within the Waimama Village Community Plan. The proposed plan development for a maximum of 1,056 single-family residential units is consistent with several policies within the Waimama Village Residential 2 future land use category and is compatible with the existing development pattern in the area. The character of the area is mainly large lot, single-family, and agricultural uses. The applicant is clustering the units in order to achieve densities in excess of 1 dwelling unit per 5 gross acres, meeting the intent of Policy 48.2 of the future land use element. Policy 48.1 states that in order to achieve densities in excess of 1 dwelling unit per 5 gross acres in the WVR2 future land use category, developments shall achieve the minimum clustering ratios, job opportunity provisions, and shopping provisions. After numerous meetings with the applicant, development services staff, and after reviewing previous WVR2 rezoning applications, it was determined that the previous applications, the two rezonings, rezoning 10-0147 and 19-0093, the employment and service requirements numbers were formulated at that time using the square footage of existing non-residential square footage from within the community plan boundary. With this interpretation, Planning Commission staff, as well as the applicant's representatives, completed an analysis using Hillsborough County property appraisers' currently built square footages of non-residential uses within the plan boundary, the community plan boundary. The Waimama Village Residential 2 future land use category requires employment and services to exist to support new residential development, which was referred to in the policy that I just named, 48.1. With the current commercial entitlements within the Waimama Village, there is adequate commercial entitlements to meet the 75% threshold of the needed household services to support the number of residential units that the applicant is proposing. 75% of the needed household services equates to 28,512 square feet of commercial land uses available within the downtown.
Sorry to interrupt,
Yes.
but right there. Let's go to the calculation of the 75%. At 75% is 2.7 is people per household?
Yes, let me grab that.
Yeah, it's right there in your report next to your,
Yes, 2.7 per household, yes.
and the 10 is what?
The 10 is the neighborhood, retail, and community commercial demand is 10 square
Per
feet
feet.
respectively per
Per
person.
person.
Mm-hmm,
Okay, and that comes out to 28,000 whatever square feet.
512, yes, sir.
Square feet. And then 75% applies to what?
Oh, I'm sorry, that is the
That is
75%,
the
the 28
75%.
number, yes.
Okay, all right, I'm with you now. Go ahead.
So picking up from there, there's currently a total of 80,927 square feet of commercial uses contained within Waimama Village. This adequately supports this development as well as the prior development approval. Also, as part of the Waimama employment and service requirements, there is a requirement to provide 55% of the needed household jobs. There would need to be 871 jobs provided within the Waimama community plan boundary to meet this requirement.
Where does that number come from? Sorry.
Well, that's okay. Let me get those calculations. So those jobs are each of the different uses, the commercial, the office, the light industrial, the government services, and residential support services. They each have a different job number created for a certain amount of square footage. So it's all of those combined for the number of households that they are requesting.
Okay, thank you.
To ensure the tracking of the commercial is completed in a uniform manner, job requirements will be assigned specific folios that accommodate the amount of commercial entitlements needed to meet the job requirement, which would meet the intent of the language in the future land use element regarding approvals and tracking. Also, to meet the vision of the community plan, the tracking will capture the jobs within the downtown first and then capture the jobs from outside of that prescribed area. The current non-residential entitlements from the West End Commercial District, which is where the Walmart is, the Waimama Village downtown, and then the Light Industrial Office District, which is on the east side, equate to providing a total of 1,699 jobs. This is sufficient to accommodate the proposed rezoning as well as prior rezonings in the WVR2 future land use category. The proposed plan development would allow for a development that is consistent with the goals, objectives, and policies of the comprehensive plan, and that it also is compatible with the existing and planned development pattern within the surrounding area. And based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan, subject to the conditions proposed by Development Services.
Okay, thank you for that. I do have a question. I'm holding a binder now full of calculations. And has the Planning Commission seen their calculations by the applicant?
We have seen, I mean, I'm just looking at this for the first time now,
Okay.
and I do believe, Unica Mills was the planner from our office that worked on this. I do believe we compared notes with David Wright from the A, B, and C areas.
Are you generally on board?
Yes. Or, no, there were some discrepancies, but the numbers are.
Generally consistent.
Yes, they're generally consistent.
That's good. Okay, thank you for that. Is there anybody here that needs to speak in support of this request? Okay, I see a lot of hands. How many actually need to speak? Because we have a limited amount of time. Raise your hand if you need to speak. I see 1, 2, 3, 4, 5, 6, 7, 8. Have you gotten together to assign a speaker? All right, we'll just give it a couple of minutes each, if that'll do it. Yep. Thank you.
Good evening, Mr. Scroll. My name is Mike Peterson. I was an individual who participated in the Waimama Community Plan formation, and I've provided materials for you summarizing our experiences and our interpretation of what was going on there. Also included in this packet are letters from Travis Council and Pat Council, both who are out of town this evening on vacation. We're supportive of the project and believe it should be approved, but we oppose the staff's new rationale on why that should be such, because it builds on this whole new interpretation about what I'll call retail job concurrency, that somehow there is a concurrency requirement that retail and job must exist before you can even ask for a residential rezoning, that, by the way, you may not get approved.
Is the
for.
bottom line to this complaint concern how you interpret 48.1, isn't it 48.1?
Yes.
Okay, go ahead.
Our experience was there was information discussed in the formation of the plan to determine how a holistic community should end up with certain ratios. But it was never presented that there was going to be some creation of a regulatory policy, a retail job concurrency that'd be applied particularly in advance of even asking for a residential rezoning.
And then how would you do it?
Well, number one, the way it was supposed to be done and the way it's currently happening is they're doing a second hit at the downtown planning effort. It commenced just a few months ago. And the idea was to now analyze how much residential is expected and how much commercial should we be planning for and anticipating in the Wiamama downtown, the 674 corridor. That effort's underway, but it's being preempted because somebody wanted to create a new interpretation because they don't want some residential development to be approved in Wiamama at this point. So this whole thing got kicked at the commission, came back for a new interpretation, and then when they realized they're probably going to get sued because the handling of this case has been horrible, they've suddenly come up with another unique interpretation to let this applicant get by, but thwart all the rest to follow. And I represent many of those people who are the rest to follow, who participated no different than the applicant, and we're not begrudging him anything. But this policy has much bigger implications than just this zoning, and it came out of nowhere. So I'm not going to belabor.
Can you give me an idea, because obviously you're limited on time, but
Right.
can you give me an idea of what the interpretation of 48.1 was intended to be, if you were there for it?
Again, simply to monitor and try to encourage any new commercial development and or job creation to be steered to the south, the SR 674 corridor, not to be competitive with it. This interpretation requires all the landowners to band together and figure out how they can now go capture land in the corridor and get in competing businesses with the existing businesses. Because if they don't do that, they're not even allowed to ask for a residential rezoning. It's madness. I feel like I'm at the end of the Bridge of the River Kwai movie. And so that it was a planning tool. It was background information. And again, what I've submitted to you in writing explains all this in detail, and it includes backup materials that were given out at those various meetings. They don't jive with what's been created. There's some revisionist history going on here, and it's just not consistent with the intent. So the only thing I would ask you to do tonight is, if you'll notice in the top handout, I have 10 questions I would love for you to engage planning staffs on, pages 2 and 3, and I think when you go a little deeper into this, you'll find out why this is such a problem for everybody. Thank you.
Thank you. Okay, next. Yes, sir.
Good evening. I'm Kenny Davis. My address is 15452 Huckleberry Road in Wiamama. I've been a resident of Wiamama for the past 50 years. I have watched the changes in Wiamama and what has occurred in Wiamama from two perspectives. One, from a citizen who lives in the community. The different perspective is the last 30 years I spent in law enforcement in this county, most of it in the Wiamama area. And it's my experience that safe, affordable housing in an area certainly improves the quality of life in that area for everyone there. And this project fits that description. And over the last 30 years, I've seen, I didn't like change any more than anybody else who's going to stand up here and be opposed to this. But the truth is that change, that progress is better than it was. If you don't believe that, you should have been with me 30 years ago on the streets of Wiamama. It's a better place now. It's a safer place. So okay. I believe projects like this continue to make that progress a reality.
Okay, thank you for your comments, sir. Yes, sir. Good evening.
Good evening. My name is Billy Bullock, and my address is 15308 Huckleberry Road in Wiamama. I was born and raised in Wiamama, and I have the intention of one day being able to buy a house and be able to have my young family close to home, to where I grew up and where my roots are. So I think that this plan is something that really fits that ideal for me.
Okay, thank you.
Thank
Yes,
you.
sir.
My name is Riley Tucker.
Why don't we go ahead and move the line up a little closer so everybody will be closer to the podium?
3909 Butternut Court in Brandon, Florida. I've been involved in Hillsborough County real estate industry since 1973 as a real estate salesman, broker, developer, builder, and in construction management. For the last 8 years, I've been a home inspector, and I'm on the HUD register for FHA rehabilitation projects. As a private inspector, I visit 12 to 1,500 homes per year, the majority of which are in Hillsborough County. And it's painfully obvious to me as I visit these different communities that what we've done in pushing high-density projects is create asphalt canyons for our young people to play in. When you visit these communities, you don't see kids outside playing. We are creating a generation of latchkey kids, whether we intend to or not. They have little choice but to amuse themselves inside. Now, as it relates to affordable housing, the number one contributor to higher housing cost is the suppression of housing supply coupled with an ever-growing demand. All zoning regulations have the unintended consequence of limiting supply. Dr. Thomas Sowell, a fellow with the Hoover Institute, a noted economist and author of several books and numerous essays, has examined housing prices across the nation. The effect of zoning regulations, rent control, subsidies, and community standards have all contributed to suppressing the supply of homes in any given geographic area. New York and San Francisco are two examples of our country's most unaffordable housing supply.
Sir, I'm going to have to ask you to wind it up pretty quick. I want to make a general note for this testimony now. We've heard this zoning already. This has been remanded for some particular reasons, and I'm trying to get those particular reasons addressed. And I appreciate your support, and if you want to end with a few words, that's fine, but there's a lot of people that need to speak, and there's a lot more hearings tonight, unfortunately. So.
I'll limit it very quickly here. A home that cost $155,000 in Houston would cost $1 million in these other areas. Today, you could take one step towards more affordable housing by making more approvals for single-family homes.
Thank you, sir. Appreciate it. Good evening.
Good evening. Cammie Corbett, representing Eisenhower Property Group. They have a substantial real estate interest holdings in the Wimauma Village area, and we would like to express support for this rezoning, but strenuously object to the Planning Commission's analysis. We think that they are reading words into the comp plan that simply aren't there and are not doing what they should do and look outside the four corners and look at the intent of the plan. I will be brief and just submit my arguments into the record and allow. Go ahead.
Do you think that the applicant's analysis then is therefore a problem?
No, because I think that the applicant had to provide a similar or counter balance of numbers to the Planning Commission, not because they wanted to or that they agreed that their prior interpretation of the plan was wrong. I think that they did so under duress, and I think that they're just submitting it because they need to get approved, and they're saying, okay, if you're going to do it that way, here's our data when we look at it that way. I can't speak for them, but that's my personal impression of what occurred.
Thank you for that comment. Good evening.
Good evening, Isabel Albert with Genesis Hab, 1000 North Ashley Street. I also am in great support of this current application, but I am in strong opposition to the methodology that the Planning Commission and Development Services staff used in order to say that jobs were there prior, have to be there prior to any development occurring. And no time in our records, and there's only been one rezoning since the WVR2, and it was done in 2010, and during those transcript and those records, there's clear distinction of there's no time mechanism that's needed or that's required.
I'm sorry, there's no what?
No time mechanism that's required, and I'll enter that into the record. And also, in no point, when you read the comprehensive plan, there's no point where it says that they have to be existing. It's the word existing that's absolutely incorrect, and I just want to put that part of the record.
Yeah, I actually picked up on that, the word existing. So that is not in the comprehensive plan language?
That is not. No, it's job opportunities, employment opportunities, services opportunities, but it's not that they have to physically be there, because when they count the heated square footage of the Waimama to determine jobs and everything, doesn't mean if that building's vacant, doesn't mean that it's habitable, it doesn't mean anything. So it's like when you start really looking into that and taking a step back and you look at the whole history of the WVR2, it was clear that the reason why they didn't want to put the employments within each planned village is they wanted to really revitalize the downtown existing commercial corridor of the State Road 674.
Okay, thank you for that.
Thank you.
Yes, sir. Good evening.
Good evening. How are you doing?
Good.
My name's Clay Taylor, 509 Donnell Street, Lakeland, Florida. My wife's family's been here in Hillsborough County in the Waimama area for 171 years. My wife Gigi would have been here, but she's in Spain doing the Santiago pilgrimage, walking 500 miles to honor her mother Gloria, who was a resident of Waimama for many, many years. James Alderman, who my wife Gigi's great-great-grandfather, was the first family of the Aldermans to settle in the Waimama area, and Alderman Ford Park is named after him. My wife and her 7 siblings, some of them are here tonight and going to speak, lived in the family house that's right there on Waimama Road 674 on Ruskin Waimama Road. They have owned property that's close to Mr. Davis's property now for over 60 years. My wife and I are both strongly in favor of the new development. The property is in the path of growth, and there's 3,000 acres in this area, immediate area, that's either owned by the state, Hillsborough County, or SwiftMud that can't be developed. So Mr. Davis's property and those like it are truly needed for affordable housing and nice developments in the area. New capital will flow into the local community and will help local farms and businesses. My family and my wife's family have a lot of pride in Hillsborough County and the Waimama area, and we truly believe this is the right thing to do now. Thank you.
Thank you for your comments, sir. Yes, ma'am. Good evening.
Good evening. My name is Marilyn Alderman, and I am a direct descendant of James Alderman, which Alderman Ford Park is named after. And I was honored to be able to represent my family when they did the expansion of Alderman Ford Park back in the 70s. Our family has lived and owned property in Hillsborough County for, since 1848. I'm not sure how many people can say that in this day and age. My mother was the first Dean of Girls at East Bay High School. She taught Spanish, taught other languages, and my father during his entire life was very involved in the agricultural and cattle industry in Hillsborough County. I come to you because I'm extremely supportive of growth, proper growth in southeastern Hillsborough County. The kind of development they are looking at doing, I think, will provide good quality homes for working families, for retired people. It will give an economic, I'm so sorry, I'm so nervous, economic impact that is going to provide for streets, schools, parks, all kinds of community services. It will help with very neglected utility services in that area. And I just thank you for taking the time and listening to me this evening. I really support this.
Thank you for your comments.
Thank you very much.
Yes, ma'am. Good evening.
Good evening. My name is Emily Puffer Strickland, and I own Windy Pond Farm, which sits on the northwest corner at 5910 Bishop Road. So we're on the northwest corner, and we are very supportive of the project. There is much needed road improvement to Bishop Road that needs to be done, and this project would allow that to be taken care of for our area, as well as new utilities and everything that the development will do at their cost. So in that sense, we are very supportive of the project and would love to see the growth in the area.
Thank you.
Thank you.
Okay. Yes, sir. Good evening.
Good evening. I'll show you what brief is. The Waimama plan, Mr. Wayne Davis spent tremendous amount of time and energy and effort, as well as a lot of landowners in that part of the world. We had something that was put together.
Mr. Carlton, did you say your name?
No. Dennis Carlton. You want the address? 4143 Moores Lake Road, Dover, Florida.
Thank you.
I'm concerned about the process. I talked to Mr. Davis, had zoning approval, planning commission approval, I guess the zoning hearing master approval on the consent agenda, and he's back here again. There's a certain amount of dollars that are involved in these things, and I think if you meet the criteria, you feel like you should receive something. And for him to have to go back through this process is a little bit alarming to me as a landowner in Hillsborough County. And as we move forward, are we going to, what are our rights going to be? How much influence is this going to have? How much is the planning commission and the zoning, when you have approval and you have your approval, you would expect something. And that's the only thing that I wanted to say. And when I hear the words compatible, consistent, and meets policies, I would expect that you would be supported. Thank you very much.
Thank you for that. Anybody else? Okay, we're going to close proponent testimony. Is there anybody here that needs to speak in opposition to this request? Okay, so I see two hands and nobody else, so I'm going to call that two. And I'm assuming you're not together, so we'll split the time up. But yes, come on. Good evening, sir.
Yeah, my name is John Godfrey. I live on 5368 Ruth Morris Road in Waimama. I had gone down to some of these meetings that they had when they were talking about development and whatnot. And at that time, it was under my impression that everything was supposed to be an acre, minimum of an acre per house. Okay, when they developed Crestview Road, all those houses are on an acre. We moved down there because, we have livestock. A lot of other people have livestock. And everything's on, 5-acre lots, 10-acre lots. And across the street from me, there's also 3 fish ponds where they raise tropical fish. Behind me, there's 2 more fish farms that raise tropical fish. We do not, in that area, have the infrastructure to handle all this extra traffic. We do not have the schools to put the kids into. With all the developing that's going on there now, the schools are all overrun.
Thank you for your comments, sir.
Okay.
Okay.
All right, thank you.
Yes, ma'am. Good evening.
Hello, my name is Noelle LaCour. My address is P.O. Box 1212, Ruskin, Florida. Good evening. I'm here to oppose rezoning request 18-1048. This application is inconsistent with the Waimama Village Plan. There is an insufficient number of jobs available in commercial establishments in Waimama. I read the list of commercial developments that the applicant produced to show the jobs that are in that area. Some of those establishments are permanently closed or seasonal. Also, the assumption used to determine the compliance with the Waimama Village Plan was 1 job per every 250, 400, or 500 square feet, depending on the development type, is a skewed representation of the actual numbers of jobs for most of those establishments listed. This proposed development will generate an extra 13,168 vehicle trips per day. Since this proposed development is located outside of the urban service area, almost all of these residents will need to travel through Sun City, Ruskin, and/or Riverview to access their jobs and visit commercial establishments. This will put even more of a strain on the roads that are already full, such as Highway 301, I-75, and Highway 41. All of our schools in this district are close to or above capacity. According to the Hillsborough County School District, Waimama Elementary has an available capacity of 55 students. Shields Middle has an available capacity of negative 815 students. Leonard High School has an available capacity of negative 1,475 students. This proposed development would add 464 students to these schools, these 3 schools, K through 12. The school district is requesting that the developer give land for a possible future school on that property. My concern is that the houses will be built before the school, and who will actually pay for the school and everything that that entails. Property taxes and impact fees aren't going to be sufficient enough. The residents of South Hillsborough County are suffering from all the residential development that has taken place over the past 15 years because the proper infrastructures were not put in place first. We don't even have enough fire stations in our county. According to the Firefighters Union of Hillsborough County, the county is 20 stations too short, with the biggest need being in South Hillsborough County. Last but not least, the Waimama Village values its important natural resources, including wetlands like the 112 acres of cypress wetlands that are located on this property. This planned development will have a huge negative impact on the wildlife and the wetlands that are on and near this property, because it's ELOT properties across the street. The bottom line is that this proposed development is outside of the urban service area. It's time to do things differently, build the infrastructure first, then the homes, stop building so close to our wetlands, and stop the sprawl into rural areas. Thank you for your time.
Are you a neighbor to the project?
I live in Ruskin, so I'm down the road, so I will be impacted by all the 13,000 vehicle trips a day.
Okay. Do you have a copy of your analysis?
No,
that you submit in the record?
What analysis?
The analysis that you just gave.
Well, what I wrote?
You just read information, statistics into the record.
Yes.
Do you have a copy of that for the record?
Not really.
What's the basis for the numbers that you supplied?
Oh, I got that all from the PGM store.
PGM store.
Yeah, and I looked at, it was put in last week by the applicant, how they were determining the number of jobs that are available. I got that from the PGM store as well.
Okay. So you're letting your testimony ride on what you supplied without any sort of documentary evidence?
Well, everything I got was from the PGM store, so it's already in there.
Okay. Thank you for your testimony. All right. At this point, is there anything else from Development Services? Okay. From the Planning Commission, I'm going to say that, obviously a complex problem, but there appears to be not a clear understanding as to whether the comprehensive plan was intended to draw discrete lines with respect to employment versus using it as a guideline. Do you hear the same thing in the discussions that you're having with the applicant?
Melissa Leinhardt, Planning Commission staff. Yes, we have heard the same commentary from the applicant and the applicant's representatives. However, the executive director, in looking at policy 48.1, Melissa Zornita, has made the interpretation that the language saying the ability to obtain maximum intensities and or densities in excess of the one dwelling unit per 5 gross acres, you need to cluster, and then you also need to provide the shopping and the jobs. And that is reflective of that language in policy 48.1.
Okay. Has it ever been applied to another zoning?
It was applied to a recent rezoning. It had the two numbers that I read into the record previously, one from 2010 and then 190093. Those were actually the same property, the 9-3 case from this year. They just added a couple parcels. So that is how it was viewed at that time. And that was the only rezoning case that existed before this one.
And is that in the tracking program now?
It is in the tracking program now. Yes, sir.
Is that a program that somebody could call up the Planning Commission and say, what's the status of jobs in
It's actually
relation
being approved, or being tracked by Development Services via the conditions, and that is why Ms. Heinrich from Development Services incorporated those two screenshots of the charts. The Planning Commission created those, so by folio, everything was listed out by use and then by the name the business is doing as, and then the heated square footage. So all of that was taken into consideration during the analysis. But yes, this case and then the one before, it's all cumulative. And that's why we're using folios, to make sure something is not counted more than one time or not counted at all.
Okay. Thank you for the information.
Thank you.
Okay, the applicant has a chance for a rebuttal.
Thank you, Mr. Scarola. Policy 48.1 is simply a guideline policy. It does not have a jobs before rooftops requirement. Pure and simple. Read it again. It doesn't say that. The Waimama State.
But nonetheless, the applicant's willing to accept it.
Right, and if you look at tab, excuse me for a second, tab 4A, you notice that, and David Wright's here if you want to ask him any questions about it, but in tab 4A on the bottom, we put a footnote, submitted under protest, not required by the WVR2 comp plan provisions. So even though we disagree with the methodology, we'll take it, we still meet it. And David's study proves that. That's competent substantial evidence in the record for you to consider. It's an empirical study.
Despite the claims by opposition that some of the number sources aren't valid.
We did the best we could with what information is available from the property appraiser, and that's the analysis. It almost proves the absurdity of the requirement, how difficult it is to prepare the analysis. Pardon me for a moment. The remand was an open record remand. All issues were fair game. That's why we addressed the school concurrency issue. We meet the school requirement under that policy enunciated by Ms. Duffy in her report.
Just out of curiosity,
Yeah.
how'd you come to the conclusion that it was an open record remand?
Well,
or was it not that clear?
Well, the interesting thing is when the matter came to the board, it was on consent agenda. It was removed for discussion, and we continued, and then at a continued hearing, it was remand open to all issues, and we felt we had to address all issues with you this evening as succinctly as possible, therefore the binder. And that's why I've incorporated by reference your prior report.
And staff concurs with that there was not a specific topic with respect to the remand, so it technically is open-ended, but we did discuss the issues that were discussed as part of conversations before the remand, yes.
Okay, thank you.
The opposition testimony is conclusory in terms of the one house per acre. The Waimama plan, as I said, was the bargain that was prepared by the stakeholders of Waimama to the 2 per acre, as long as they meet clustering requirements and the job opportunities, which they have done. We comply with the law. There's no evidence in opposition, no competent substantial evidence in opposition. I urge you to consider, of all the testimony from the stakeholders, besides Mr. Davis, read what Ms. Alderman told you. Over 100 years, 1848, that family's been there. And they have told you this evening that this plan represents the bargain they made for their stakeholder in their property, their most fundamental property right. Excellent testimony.
But the issue in and of itself of the clustering is not, even though you've said it's an open remand, I haven't really heard, that wasn't the
There was
issue.
no dispute on that. I think the board, maybe in an abundance of caution, said that the remand would be open to all issues. Obviously, we wanted it narrowed to as few issues as possible because your report was a recommendation of approval and we were on the consent agenda. But we've been trying to cover all points with you in a limited amount of time. Do you have any questions of us this evening?
I think I have enough information.
I'll summarize. And it's a personal summary. I've been reading a book about the Spanish conquest of Florida. When the Spanish galleons left Spain to conquer Florida, they did not ask if the jobs were there first. They came, they built the communities, and then the communities came after and the jobs. It's very simple. Look at Jamestown. They came and they sailed the communities, the jobs came after. It's a very simple issue. It's been way too complicated. I submit your request that we approved and we have your recommendation of approval.
Okay, thank you for your testimony. With that, we'll close the remand on 18-1048. Brian? Come on, Brian. Susan's gonna get out of here in a second.
Want to take a second?
Oh, my God. So you're feeling terrible.
So he's the only one authorized? Well, we're gonna try to take a break before, we're gonna take a break before we get, so we can talk to Louis about that. Ready?
Brian, go ahead.
The next item then is agenda item B2, rezoning application 18-1163. The applicant is Michael D. Horner. The request is rezoned from M manufacturing to plan development. I'll provide staff recommendation after presentation by the applicant.
And ladies and gentlemen, please, we're conducting a hearing. If you wouldn't mind just keeping it down until you're out of the room. Mr. Horner, go ahead.
Good evening, Mr. Scarola. For the record, I'm Michael Horner, 14502 North Dale Mabry Highway, Tampa, Florida, 33618, representing the applicant, contract purchaser, Broome Capital Development, LLC. With me this evening is Mr. Tom Levin of Ekistics Design Studio. We'll be speaking briefly just on a summary of the EPC issues. And then Jordan Ferralis is also here this evening, but he's probably not going to speak unless you have other questions as the developer. Mr. Scarola, we stood before you here on January 22nd.
But let me say in advance
please.
that my understanding is this remand was asked for by you. Is that right?
Yes.
For the purpose of the EPC related matter.
That's correct.
Okay, we've had the hearing.
That's correct.
So we're going to limit it to the EPC related issues.
That's correct.
Okay, go ahead.
Absolutely. We don't want to stray. So we are here solely because of the hearing on January 22nd that could not receive staff recommendations for approval, as you noted in your filing February 12th. That case was remanded back at our request from the Board of County Commissioners because we had unfavorable recommendations based on the EPC recommendations at that time. Since that time, we have worked diligently with EPC. We have worked through all the entire impact justification requirements. Unfortunately, EPC, I shouldn't say unfortunately, fortunately approved it, pleased with that, but they filed their recommendation and specific findings 48 hours after the filing of the staff report.
Let's be clear about what they approved. Did they approve the impact justification?
Yes.
So you have an EPC wetland impact justification?
Yes.
Was that given to staff before the staff report?
If you let me finish.
Okay.
EPC filed that wetland authorization approval 48 hours after the deadline for the staff reports to be filed. So this is why, Mr. Scarola, that I approached Mr. Grady and said, where do we go and how do we proceed? And Mr. Grady was kind enough to say, we will amend our reports on record and change the findings to consistent and supportable based upon the EPC wetland justification approval that was issued on June 11th of this year.
Was the Planning Commission made aware of it?
Yes, we sent the copies to all parties.
What I advise that what Mr. Horner said is not exactly accurate. What we said was we would acknowledge on the record the basis for our non-support was related to the EPC comments. I'd advise we couldn't amend our report because we had already filed that. So we would acknowledge the reasons for our non-support was the issue of the EPC mitigation, and so we would acknowledge that submittal of that information from EPC addresses the concerns, which I was going to bring up in my report.
Okay,
so.
I'll let it go, but I hope we don't get to the point where it's then we have to modify the conditions. So this thing's been tied up?
We're going to file the same conditions we filed to you January 22nd.
All right, they're not staff conditions, they're your conditions.
That's right, and staff has reviewed them. In fact, staff proposed those conditions that we submitted to them January 18th.
Okay, go ahead, Mr. Horner.
All right, thank you, Mrs. Scroll. So again, we have worked diligently with EPC. We could not get that report filed in time for staff to amend their reports formally by the time they filed their deadline report into the record. I would incorporate all the proceedings of the January 22nd exhibits. I'm not going to duplicate any testimony from the January 22nd hearing, and I would simply note in your summary on February 12th, on page 14, that this report, as well as reports from the Planning Commission Development Services, concludes that the PD proposal would result in development that is compatible with the surrounding area. Further, the residential development would be occurring east of the significant wetland areas that border George Road, which would substantially buffer and screen the homes along George Road from activities that are internal to this site. All of those assumptions, all those parameters are part of our filing. The only outstanding issue was having EPC approve not just the conceptual mitigation plans, and in fact the record shows the January 22nd hearing. I said, Mrs. Scroll, I think we are weeks away from EPC's approval. I could not have been more wrong. So on June 11th of this year, after 4 months of additional reviews and sufficiency comment response periods, we received that letter, stamped, signed. We filed that into the record, into the staff. We filed that with the intake form, and we'll file another copy in the record tonight for you. This is an infill development, same number of lots, Mrs. Scarullo, 72, 37 townhomes, single-family attached, and 35 single-family detached. It implements the SMU 6, and there could not be a better classic case of urban infill development than this parcel, because we are adjacent to the Benjamin Road Industrial Corridor, which is LI, Res 6 to the west. We have industrial uses to the south. We have industrial uses to the east. And we are asking for this M zoning to go to PD to allow for an urban infill development. In terms of policy 1.4 from the Planning Commission staff, the FLU, future land use element, we are at 4.9 units per acre, which exceeds the 75% minimum provision codified in that policy. The total wetland impact out of 14.5 acres, Mrs. Scarullo, was 0.5, and now it's actually 0.41 when you exclude the interim temporary impacts proposed. And I would submit to you the majority of those impacts.
So a portion of the 0.5 was temporary impacts, and
That's
left
right.
the remaining 0.4. Okay.
That's right. And a significant portion of that 0.41 is for the necessary access road to come in off Georgia Road.
Mr. Horner, there were two significant issues. One was the wetland impact. The other one was the wetland setback encroachment issue. Let's get to that.
We have no inconsistencies with the natural resource 30-foot wetland setback or EPC's wetland setback. So
with the site plan as it sits today that I have.
That's right.
Okay.
That's right. So before we added contingency opportunity, we asked you to allow an allowance for a LUHO proceeding afterwards that would allow this process to continue. Mr. Grady indicated that was not the current policy. We got caught in the middle of that. So we had to regroup, prepared all new site plans, went back to EPC, removed all those issues. We are now 100% compliant with all natural resources, and now with EPC's approval through the mitigation
Just the
approval.
logistics of it. So when the wetland impacts were approved, it backed the wetland off so that, I'm assuming this, so that the encroachment, the wetland setback issues were no longer.
Essentially, that's correct.
In general.
Yes, yes, sir. Okay. And then I'll just close before I introduce Mr. Levin with the transportation assessment, which was carried over. I just want to highlight it for you this evening, which indicates, since traffic was brought up before at the 22nd hearing, and that was based upon the number of trips that was being proposed, and we are actually reducing those trips by almost 100 trips per peak hour. Staff noted, this is under 1.3 of the staff report in transportation. Staff noted the proposed rezoning is anticipated to decrease the number of trips potentially generated by this development by 933 average daily trips, 172 AM peak hour trips, and 138 PM peak hour trips.
Is that changed from the prior
It did not, but I thought it was worthy of mentioning again in the staff report. I'm going to file our proposed conditions, which were essentially the same conditions we introduced in the record on January 22nd. The only clarification, as I noted to Mr. Grady, was a clarification of the front setback to the garage being reduced from 20 feet to 18 feet, which was also incorporated in the January 22nd. So with those, we stand, I believe, in full support on appropriate land use that is clearly an urban infill development with full EPC approval, no waivers and no contingencies, and I'll be happy to answer any questions.
Tell me about that 18-foot front setback. I'm not recalling it.
Yeah, it was the RZ-10, which is a standard set of conditions for the front garage setback, is either 20 feet. And then you have the representation of the side coverage for the garage. We meet all those, but we ask for the opportunity to encroach a little bit closer to the right-of-way of 18 feet instead of the 20 feet. That's the only change to the RSC 10 conditions that we asked for.
There is no zoning district that has an 18-foot setback, is there, front setback?
That's correct. So that's the relief that we requested as part of this approval. And that, Mr. Gray, indicate any objection to that.
Okay.
That concludes my presentation. I'm going to file these documents in the record and introduce Mr. Levin, please.
Okay.
Thank you.
Thank you. Good evening.
Yeah.
For the record, I'm Tom Levin, President of Acoustics Design Studio. I'm here with the project that represent the issues that were related to the wetlands and the wetland setbacks. Let's see.
There you go.
Okay, I can make this a little bit bigger. Let's see.
I think you have it upside down.
Oh, that might help to.
There you go.
Straight down. Okay. Trying to get it as big as possible. Oh. I've got it. It is on, I think. Yeah. So this site.
You got to push the button up on the microphone.
It is up. Test.
Now you're on.
This site is directly south of Channel G, which was a man-made drainage canal that was built in the 1960s that drained this area. It actually allowed most of Town and Country to be developed. That, along with the couple of the other channels that are going through that area, they all have alphabet letters. But Channel G is really close to here, and it diverted all the runoff from Sweetwater Creek. These wetlands on this site were originally part of the headwaters of Sweetwater Creek, which was obliterated by the canal. So this particular wetland system has been dewatered both physically by ditching and draining, as well as by lowering of water tables by digging the canals out. So this site has kind of been kind of a hole in the donut for development in this area because of the industrial on one side and residential on another side. But it has actually had a pretty intensive agricultural use. I've never seen hogs so big as on this site. And they virtually have torn up huge areas of the wetland. There's big hog wallows in there. I was expecting to see, moonbeam mixed swine in there, or something with the hogs. The vegetation in the area is dominated mostly by non-native nuisance vegetation that has colonized the area. So from the standpoint of the existing system, it was pretty well impacted by surrounding development in the region, as well as by the current intensive agricultural use of the property. There's also goats in there too that are impacting the area. So when we did this project and we started looking at the impacts and how to minimize impacts, we've gone through 8 or 9 iterations on minimizing impacts. As you can see on the plan, there's the I don't have a pointer here. Let's see. I could do this. But this is the entrance to the property, which was moved in an area where there's an existing berm. This wetland A actually was a former stormwater retention pond that we were unable to find the 17.4 permit to verify that it was a stormwater facility. Therefore, it's treated as a wetland. This area here is wetland B. which again has the ditch connection to Channel G that we talked about. And Wetland C over here is a smaller area that is tributary with a ditch, again going back to Channel G. So as you can see, in order to make use of the site, access was required, and we located it where the existing berm was. The existing berm was narrower than a county road, therefore there would be impacts on either side of that. As a clarification on the .41 impact, this area in here was an area, as opposed to temporary impact, we had a man-made ditch that did qualify as an exemption, and that would be exempted from a wetland impact review and analysis as a man-made ditch. We have, so the major impacts are along the road in here. The site plan has been adjusted and modified, and I know you made a mention about the 18-foot, like, front setback. But we have already, in order to make the rows of lots, to be able to fit 4 rows of lots in here and minimize wetland impacts, we've already made the lots 100 feet deep. A lot of the 40-foot lot product has deeper lots, and we felt that we would minimize some of the impact into that wetland by having shorter lots and also having the additional 2 feet to work with. If you look on the plan,
let's start wrapping it up now. We got more here.
If you look at the plan, we have adjusted everything so that 30 feet works. The reason that we didn't have the approval when we wanted to have the approval, because there was a lot of discussion about 4 lots that are in this area, where again the impact tied into the fact that we needed to have some additional impacts in order to make the setback work, which is a harder justification than, let's say, essential for access kind of requirement.
Yeah.
But in the end, the site plan that you see was approved for impact review, and I think that satisfies the requirements of what planning staff was looking for and why the remand was remanded. And to get this on the record, you should have everything that you need.
Thank you, Mr. Levin. I appreciate the testimony. And Mr. Horner, anything else?
No, sir. Thank you.
Okay, thank you. And Development Services?
Brian Grady, Hillsborough County Development Services. As noted, the request is rezone the parcel for 72 units, 35 single-family conventional dwellings and 37 townhomes. The nature of that request has not changed. As noted previously, the primary concerns staff had with this request was impacts to wetlands that were not yet approved, which was driving needs for potential for also wetland setback variances and non-compliance with the minimum lot area requirements of the code. And again, they were presupposing approvals that were not done at the time of zoning, and staff had issues with that as outlined in the report previously and in this report, because at the time of the filing of the staff report, that mitigation approval from EPC had not been provided, so the same issues applied at the time of our filing our staff report. As noted, subsequent to the filing of the staff report, the applicant did submit the mitigation approvals from EPC. Again, the lack of those mitigation approvals was the reason for non-support by staff, because again, as outlined in this report and the previous report, we did find overall the request was compatible with the area, but again, we had issues concerning those lack of approvals, and that was the basis.
So in short, with the approvals that are now on the record, those concerns are no longer...
They've been addressed.
They've been addressed?
Yes.
Okay, thank you for that. And the Planning Commission?
Melissa Leinhard, Planning Commission staff. The subject property is located in the suburban mixed-use 6 future land use category. It is in the urban service area, and it is within the limits of the Town and Country Community Plan. As of the date of the Planning Commission staff report filing, which was June 5th, the applicant had a pending wetland mitigation report under review with the EPC, As at the date of that report writing, there had been no official determination of the EPC to either approve or deny the proposed mitigation. Because the submitted site plan showed definitive wetland impacts and a mitigation report had not been approved, it is not possible to find the proposed plan development consistent with the comprehensive plan at this time. But again, as Mr. Grady had already indicated, we are not able to change our finding after our official filing of our with our staff report, but I can acknowledge that our inconsistency finding was based on the wetland impacts.
And have the inconsistency findings been addressed?
Our inconsistency was based on the wetland impacts.
But the impacts no longer, the impacts are approved. Would that affect the comments that the planning commission had?
It would certainly affect comments moving forward, but at this time, the filing of inconsistency still stands.
Okay. Anybody here today in support of this request? Okay, see none. Is there any opposition to this request? Okay, how many need to speak? Hold up your hand high if you need to speak. Okay, I see 1, 2, 3 that need to speak. Is there an assigned main speaker? All 3 will be very short. Okay, thank you. Come forward, ma'am. Thank you. How are you?
Hello. I'm pretty good.
Good
Hello,
evening.
ladies and gentlemen. Thank you for taking the time. Let me switch my glasses real quick. My name is Susan O'Farrell. I live at 6708 George Road, and I am speaking tonight in reference to RZ-18-1163. The last time I stood before you to oppose this unattainable idea, I tried to address the specific concerns raised most passionately by my neighbors. Since then, this case has been an excessive amount of time to collect any and all paperwork to pass the necessary zoning regulations. Postponement after postponement every month to morph into the perfect project on paper, obscuring the impact on this proposition. This will have a big effect on our community. It will fatigue those of us who are invested and who understand it. At the start of this ordeal, we collected over 350 signatures in an established development called the Town and Country Park. Everyone that lives in this area knows that this is a bad idea. Tonight, I would like to focus on the most pressing urban planning issues with Mr. Horner's proposals, starting with the roads themselves. The traffic counts that Mr. Horner has presented looks usable on paper, but are self-centered for the purpose of his sale and do not actually represent the real traffic flow at the intersection of George and John's.
Okay,
Road.
let me say this to you. I'm going to give you a little bit of latitude because of the time that's been put in this, but we're here today on a remand. It was about the wetland systems and the traffic issues. You had an opportunity to address them, which you did, by the way, which were also addressed in my report. So if you would, I'm more interested in the wetland issues at this point.
I felt that we had 15 minutes to speak, and we have 3 people to speak, and I guess that I was able to reiterate a little bit. I will get this out as fast as possible.
Okay.
We need the improvements on George Road. He just talks about what he's planning to do in his little area we need to be able to merge this onto John's Road, and these are addresses that we don't know exactly how to address to you all, I assume, because John's and George Road is something that needs to be addressed in order to put 72 homes down in this corner pocket. As far as the George Road's improvements alone to get into this little pocket, it's not going to be satisfied. Our roads need the same standards that his roads are getting. This includes the size of the roads, the non-existent gutters that we have, the drainage problems, the replacement of streetlights. We pay for our streetlights. Every single person on this block pays to the county, where everybody else, the county pays for this. So, you know, we are just continually being downgraded in this existence. Last but not least, I ask that you go over the plans for the Town and Country Greenway itself. The county has already put into place for expansion the Town and Country Greenway that ends at George Road. I need to mention the amount of money that has already been spent to make George Road the most perfect spot to extend this Town and Country Greenway from Channel G that was just expressed from Mr. Horner and his constituents. It's taken a lot of years to plan where this ends up and the wildlife that is there. I feel that this is a place of peace and quiet, and this is very much a disruption. So I apologize if I've already said something that I already said, and I do have some new pictures to put in, and I thank you for all of your consideration, and I hope that my speaking here tonight has helped see all of my neighbors' concerns for the health of our community. There's a difference between urban development and urban drowning, and I hope that all of you keep that into consideration.
All right, thank you for your testimony. Yes, sir. Good evening.
Thank you, Commission. My name's Ted Mavis. I live at 6810 George Road. I'm a neighbor of Susan's, about 5-6 houses down. I wanted to submit some pictures. When they were saying no, there's not native plants, I wanted to submit, I don't know if they can see that or not, but you call an 85-year-old, 100-year-old oak tree, 30-foot buffer. This is exactly where this oak tree is where their projected entrance to the project is. I don't see where they're coming up with, okay, I read something where we're going to replace that with like 8 or 9 oak trees. Well, yeah, but this is a 100-year-old tree. There should be, and the neighborhood is peaceful. On this picture, I simply show children. We have many neighbors that use the bike trail and come down to the store and get a soda and a sandwich and stuff. And with the traffic and the wetlands, they're going to destroy a beautiful piece of park. And I just want to keep it simple. They pretty much said everything. We said everything on the last hearing about the traffic and the lights, and I understand. But I just don't want to see such a beautiful place with another 70 houses coming down this road, no matter how big you make it. And we all know the trouble. Look at Bay News 9 every morning on Hillsborough Avenue. That's where all these people are going to go. We're going to be just, thank you for your time.
Thank you for your comments, sir.
All right.
Okay, yes, sir.
Someone's glasses here?
Oh, somebody left their glasses up front. Good evening.
Hi again, I'm John Sidney Davis, Jr., technically. I live at 6812 George Road. I live directly opposite the entrance, or the proposed entrance to the development. I'll try to restrict it to the environmental impact.
Thank you.
But keeping in mind 72 houses into that area has a significant environmental impact. The current density in that neighborhood, I went on Google Earth today, 72 houses, is 12 acres. And given that they have 14 acres roughly, and part of that is wetland, they're having the most dense housing area in that neighborhood. So that in itself will have an impact. But what the property, just to give you an idea, it is Channel G, thank you, I didn't know that, but that's to the north. Veterans Expressway is adjacent to it on the east, and then manufacturing on the south, and then George Road, 17-foot wide George Road, is on the west. There's no real access to that property. The address is Johns Road, and yet they're proposing to cut a swath through the wetland and the oak trees to open up onto George Road that barely has enough room for 2 cars to pass. So that certainly has to have a significant impact. I suggest that their desire to do that is to improve the curb appeal, perhaps, of the housing project, because there are currently 2 roads that reach that property. One is at Axelrod Road, and the other is the street directly east of Axelrod Road. There is also a third alternative, which is the kind of exit perimeter road at the office complex there. All of those are at least 25 feet wide. I measured them today. So at any rate, their original traffic study, I don't think, included the impact of the trips per day for 72 houses. And I think that the number of critters that migrate during the season from those wetlands to the other areas would be impacted as well. I just happen to live there and I see what goes on there. I appreciate their focus on the environmental issues, but they're focusing on details and not looking at the broader picture. It's as though they're looking at the proverbial the flea in the elephant's ear and not looking at the elephant, the ethical elephant in the room. So I applaud them for squeezing what they can into the environmental thing to get their EPC apparently approved. I might add too that they've had quite a bit of time to do this, at least a year perhaps. We're 10 residents. They have lots of money, lots of funding. They've had a lot of time. They have been late, delayed, whatever. This is the second hearing I've spoken at, and it's been denied for a reason. And again, the original people who deemed it manufacturing had a reason for doing that. I don't know that I want to live right under the flight path of TIA and Veterans Expressway. So now they're saying they meet the specific requirements environmentally. And I understand people are saying it's consistent. At the same time, I may have the qualifications to be President of the United States. That doesn't mean that I'm the right person for the job. Just because they have the ability to meet the technical requirements doesn't mean that it's consistent with the Hillsborough County development plan. So I please ask you to deny this.
Thank you very much for your comments and testimony.
Thank
Appreciate
you
it.
for your
Okay.
time.
Yes, ma'am. Good evening.
Karen Mahalski, 7903 West Whitewater Court, Tampa, 33637.
Where's that in relation to the project?
It's not, I'm an activist, and just like to point out some policies that are, that protect the wetlands and protect the environmentally sensitive lands.
I think you just told me you don't live near the project. Is that right?
Correct.
Okay.
Correct.
Thank you.
So
Go
I'm
ahead.
speaking as an activist.
That's all right. Go ahead.
In the Hillsborough County Conservation Aquifer Recharge, there's policy objective 4 for wetlands and floodplain resources. I don't need to read them because I'm going to submit it. And then in the comprehensive plan, objective 13, new development and redevelopment should not inversely impact environmental sensitive lands and other significant natural systems as described and required within the conservation aquifer recharge element and coastal management elements comprehensive plan. And then there's some policies.
Thank you for your testimony. All right.
Do I need to sign these or put any notes on these? I don't know that policy.
On your submittal?
Yes.
If you would, just sign in with the clerk, and they'll take the exhibits from you with your recorded name. Yeah.
Mr. Scroll, before we go to rebuttal, I just want to point out for those who spoke on this case that if they have any questions regarding filing of oral argument, Fernando Quinones, who's sitting right over here, is raising his hand, can assist with their questions regarding filing that information if they would like to speak to him after the hearing closes.
Thank you for that. Okay, so with that being said, anything from Development Services? Okay, and the Planning Commission? Okay, and Mr. Horner, your opportunity for final rebuttal.
Thank you, Mr. Scroll. I'll be brief. The only reason we picked this site was the same reason that they picked this site years ago when they found their home sites desirable. It is at the terminus of George Road. There is no through traffic on George Road. We have direct connectivity to the Town and Country Trail headway, which is right catty corner to this site. We are preserving the majority of those wetlands, having only nominal encroachments for the access. We have worked hard to resolve all of those issues. Had it not been for those nominal encroachments and the requirement now to have the detailed impact justification approved, we would have had unanimous recommendations before. The only objection of record by the planning staff was the absence of the EPC wetland impact justification approval, which negated the need for waiver relief for the 30-foot setback for EPC and natural resources. We have done our homework. We didn't ask to delay this project just because we felt like delaying it and spending an additional $100,000. My client said, we have to do the right thing. The old days are over where you said it's permitted subject to a contingent approval later on with the EPC. Now staff has held our feet to the fire and said, you have to go through this entire process. And we still don't have an approval. And we may not. That's the risk a developer takes nowadays as opposed to up to this point from years ago. That is commitment to a process. That is commitment to resolving issues that come up. That is a commitment to an urban infill that is on M-zone property. We don't have any other opportunity for access, Mr. Scrolla. In fact, on January 22nd, I filed the industrial warehouse plan that was approved that has truck traffic going back and forth on a portion of that property. We are essentially having a 300-foot buffer. None of those residents on George Road will be able to see our units. And that 100-year-old oak tree, Mr. Mavis brought that up at our meeting at Golden Corral months ago. And we went back and redesigned that front entry and committed ourselves to work with natural resources to save that and work with that. We have done our detailed transportation study. We have the only competent, substantial testimony on record and evidence. We are doing the road improvements. We are expanding by 2 feet, widening George Road. Mike Williams, detailed engineering staff, James Ratliff can offer that testimony. We've gone through that process, not easy. We have to accept all the drainage. We have to do all the site improvements, sidewalks, internal sidewalks, street lighting, drainage, all of that to get the 72 lots, which again, I remind you, is just above the minimum of the policy 1.4, 75%, which is 4.5 units per acre in Res 6, SMU 6, and we're at 4.9 units per acre overall. There are only 4 lots abutting us to the west. We have tried to be fair. We have tried to offer ourselves for discussions. I've sent all of our meetings, our notes, our revisions, our plan iterations, even our final EPC impact approval to Beth Gagne last week and said we now have achieved that. Took us a while, took us a lot of time and a lot of money, but we achieved that. Absent that approval, Planning Commission's report indicates that was the only objection they had. Staff, Development Services indicated the wetland issue was the only objection they had. We've worked hard on this, Mr. Squirrel. We appreciate your support. Thank you.
Thank you, Mr. Horner. And with that, we're going to close rezoning 181163, and I'll turn this back over to Hearing Officer Finch.
All right, thank you so much. At this point, because we are going to now go to the special use items, I'll ask Mr. Whitehead of the County Attorney's Office to explain the procedure for the right to appeal special use decisions. Mr. Whitehead.
Thank you, Madam Hearing Officer. Louis Whitehead, Assistant County Attorney. Decisions of the hearing officer on special uses heard tonight will be filed with the clerk of the board on July the 9th. The Land Development Code provides that anyone who desires to receive a copy of the decision by mail must furnish the clerk of the board with their name, address, the case number, and a stamped self-addressed envelope. Decisions of the hearing officer on special uses may be appealed to the Land Use Appeals Board. An appeal must be filed with the Development Services Department within 30 calendar days from the date that the hearing officer's decision is filed with the clerk of the board. The following persons or entities shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. First, the applicant, and second, any person or entity that is present or represented at tonight's hearings and presents either testimony or documentary evidence, or B, submitted documentary evidence themselves or through another prior to or during tonight's hearing, and C, is adversely affected by the decision of the hearing officer. The evidence that the appeals board can consider is limited to the evidence that is presented tonight. This means that at the end of tonight's hearing on each special use, the case record closes and no new evidence may be submitted. Thank you very much.
All right, thank you, Mr. Whitehead. Because we've had some people coming in and out, let me just ask, is there anyone that wants to speak tonight that has not been sworn in? Okay, if you could, stand up, raise your right hand, and I'll swear you in real quick. We'll make sure we get this done. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, and so help you God? I do. Okay, thank you so much. Mr. Hisney, if you could please call the first case.
First case tonight is item C1, application number 19-0581. The applicant is Woofs and Tweets, LLC. The request is for a 4 COP alcoholic beverage permit, which requires a distance separation waiver. Staff report and recommendation will be presented by Lori Boylan.
Okay, good evening.
Good evening, Ms. Finch and everybody else that's here, and I appreciate you taking this time to hear our application. My name is Ben Stronzel. I'm with Mandelbaum, Fitzsimmons, Hewitt, and Kane. I represent the applicants. Our address is 100 South Ashley Drive. It's Suite 1100 right here in Tampa. The two applicants are Robert Pierce and Jerry Inskeep are right here. Before I get into the specifics, I just want to mention that Mr. Pierce is a retired Army Major, and he was a retired Hillsborough County school teacher for 10 years. So this is an application for special use wet zoning at 19651 Bruce B. Downs Boulevard. It's in a small strip plaza north of Cross Creek Boulevard. The plaza faces, well, the stores in the plaza face to the west towards Bruce B. Downs. It's directly across from the city of Tampa, so we're very close to the city of Tampa limit there, if you're not familiar with the area. This is a plaza that has struggled over the years for tenants. This is an area of Hillsborough County that has not seen the development that other areas of Hillsborough County have. So these two gentlemen are trying to start a piano lounge / karaoke lounge in that plaza. We are here tonight seeking, it's in compliance with all land development code, else than 3 waivers that we're seeking, and they're all distance waivers. And I'll address those waivers, each of which have special and unique circumstances that justify each request. So the first is a community use waiver. There's 2 of them actually. The Tampa Presbyterian Church is 463 feet away, and the rules require 500 feet. We're seeking a 37-foot waiver. The Tampa Presbyterian is 463 feet north of the premises that we're seeking the subject use. There is a road in between there that leads into the Pebble Creek neighborhood. There's also a pond in between there. The hours of that church are inconsistent with the hours of our facility, so we don't believe there's going to be any significant impact on the people utilizing the church and the people coming and going from the strip plaza. In addition, the traffic flow, we don't believe there'll be any adverse traffic impacts based on the subject location. It's in a strip plaza that has plenty of parking. Bruce B. Downs is already full of traffic depending on what time of day it is, but it's been expanded in the recent years in this area to include additional lanes going both north and south. The other community use waiver that we're seeking is the Pebble Creek Homeowners Association pool. Now, this is a waiver, we're asking for 480 feet because the technical line is 20 feet, this pool, and we have photographs that I'll put into the record so that you can see them if you would like, and it's also in the staff report. You can see it from the photograph, the overhead photograph. While the pool is by rule 20 feet away because it's directly behind this facility, I believe, and this is consistent with the staff report, the normal route of travel is actually 1,200 feet. You couldn't walk from the back of this, from our facility to this pool. First, there's multiple trees, there's a roadway, and then there's a concrete barrier that's supported by, I don't know the exact height of the fence. We have photographs of that. It's about a 6-foot high metal fence with pointed edges at the top. This is not something that we believe will be, that will adversely affect that use of that pool. The pool's hours of operation, which are on their website, are, hold on here, 10 a.m. to 7 p.m. While that does overlap slightly with our hours, which will start at 4 p.m., it's not expected that there will be a significant overlap since the majority of our business will be at night, starting right around that 7 o'clock time. But I do admit that there is some overlap of the times there. In addition, there is no direct travel path to this pool. The rear of our unit, per the fire code, does have a rear exit. It will be an emergency exit only. It will not be available to patrons else in an emergency. There will be no re-entry allowed from that rear exit. So there will not be people congregating behind the facility near where the pool is. We believe that those circumstances justify that waiver request, which, although looks large at the 480 feet, the reality of that request is much less significant. And we believe there's already been a waiver granted, although I was not able to confirm this because there's an established 2 COP in this lot as well. The HOA pool, though, I believe, and don't quote me on this, I believe was created or was built after that, but it's also within the same corridor there. Going to the next waiver, and the last waiver is a residential zone waiver. 250 feet is the distance requirement. The Fairway Villas are 238 feet away from our facility, so we're asking for a 12-foot waiver there. The Fairway Villas lie behind to the east of our property. And like I said, when we're talking about residential zoning or residential areas, there's a concern for noise. There's a concern for whether or not people are going to increase foot traffic, increase car traffic because of that. There's no direct roadway from our facility to that residential neighborhood, you would have to go out of the strip plaza, make a left, and then make another left to get into that zoned area. In addition, this is a piano and karaoke bar, so obviously there's going to be music, there will be some noise. However, that noise will emanate out the front of the facility, which will face westerly towards Bruce B. Downs. In addition, our clients this is not the first facility that they've owned, the first piano or karaoke lounge that they've owned. They're very aware of the sound and how that can affect not just the residential neighbors around there, but the other businesses as well. So they've spent considerable time and money to, obviously not until they get this approved, if they do get it approved, but they have plans to spend considerable money on sound mitigating foam that's common in a lot of bars and different lounges like this, that is sprayed into the walls and into the ceiling at a high cost, but it does help to mitigate the sound from emanating outside of the building. We are aware of, it's our understanding that there have been several local residents who did raise complaints about noise issues, and I think one of the other issues was they were concerned about drunken misconduct from a piano or a lounge type bar. And we're also aware of several people, local residents, who voiced their support for the location. This is an area without a ton of entertainment or bars or clubs, as I'm sure you're aware already. We did reach out personally in my office to the people who had voiced concerns, and we didn't receive any response. We wanted to try to speak with them, address any issues. The issue was the noise. We could have talked to them about the foam, the sound mitigating foam, and other things that we're doing to prevent any kind of disruption to the neighborhood or to the livelihood of people who live there. Not allowing re-entry from the rear access is another strong point that we want to talk about, because there won't be any congregating of people back where these homes are. Hopefully there's no congregating of people out front either, that's a parking lot, but there won't be traffic or people out back, okay? The people that offered support and are excited about this also is in the record. Those came through by emails to the hearing council, and we believe that their concerns should also be considered by the board. Now, this is not the first establishment like that these gentlemen have owned. The expected age range of the patrons that will be coming there is 40 to 70. It's not a younger crowd that they're seeking. It's not a college crowd that they're seeking. We believe that the waivers that we requested are reasonable. We believe that they're fair. We believe that special and unique circumstances exist for them. We believe that when you see the overhead of where this is, the strip plaza that it's in, compared to where the church is, compared to where the pool is, and compared to where the residential neighborhoods are, that it's easy to understand that these waivers are reasonable. We are submitting these photographs into the record that are from, I believe, Google Maps, and they mimic what's in the staff report, just close-up and color versions. So my clients are here. There's also distance measurements on them as well for you to see. That's part of the property appraiser's system, which is great. My clients are here to answer any questions. They have their interior designer here to answer any questions. They also have their contractor here, who were all sworn in, that can answer any questions. Should you have them, I can answer any legal questions, hopefully. Should you have them, and this is Miss Christina Del Grosso from my office, who helped me with this project, and she's here to answer any questions if you have them as well, ma'am.
You answered some of my questions. I just had a follow-up as to whether you spoke to and approached the church, the homeowners association, and the Fairway Villas residents.
So we sent, I'll answer that in three parts. For the Fairway Villa residents that complained, we did send email correspondence to them based on the addresses that were used for the complaints that were sent to us, and we did not receive a response since I've been here tonight at about 5:30. I have not checked my email since then, so it's possible that in that short period of time that we did get one. We did not get any response or complaint from the Tampa Presbyterian or the HOA facility, so the fact that we did not get a response, they were issued notice, but the fact that we didn't get a response, we did not reach out to them. Subsequently, we believe that they didn't have any complaint or issue.
So both the HOA and the church are in your notice area?
Yes.
Okay.
Yes.
And you didn't hear back from them?
We did not hear back from them. Had we would have reached out and tried to. We were very willing to address any concerns that anybody had, and to this moment, if anybody is here complaining, we'd love to talk to them and speak to them. These gentlemen are looking to start a community-friendly establishment and support the community, bring jobs to the community, bring money to the community.
Okay.
So.
That was my only questions.
Okay.
Does that complete your presentation?
Yes, I'm trying to be brief. We all sat through a couple long presentations, so.
Yes, absolutely.
Be as brief as possible.
Thank you for that. I appreciate it. And you can, while you sign in, you can submit your evidence into the record.
Yes.
Thank you so much. All right, Development Services. Good evening.
Lori Boylan, Development Services. I will try to rebrief since the applicant was very thorough in his presentation. Pursuant to the Land Development Code, the request is for a distance separation waiver for a 4 COP alcoholic beverage permit for sale of beer, wine, and liquor for sale and consumption on and off the permitted premises. According to the applicant, the proposed wet zoned area will consist of 2,729 square feet for a proposed Woofs and Tweets Lounge. The establishment will be located in the shopping center on the east side of Bruceby Downs between Pebble Creek Drive and Regents Park Drive. I just want to note that he called out his waivers for his community uses, his residentially zoned property, but he does not need the waiver for more than 3 existing wet zones within 1,000 feet. He complies with that. I'm going to skip to save time because he was exact on point with his distance waivers. If that's okay, I'll go to staff findings. The subject location is proposing a 4 COP wet zoning for Woofs and Tweets Lounge with no outdoor patron area. The proposed lounge will be located in a shopping center that is oriented towards Bruceby Downs, away from the residential homes and community recreation use to the east. The proposed wet zoning is separated from Fairway Villas at Pebble Creek by the south end of the shopping center, the service drive at the rear of the shopping center, a cluster of trees, Bent Tree Drive, and the community pool. Fairway Villas at Pebble Creek is surrounded by a masonry wall, and the normal route of travel from the front entrance of the proposed lounge to the entry road to the Villa Community Tournament Trail is approximately 900 feet. The proposed wet zoning is separated from the church by the north end of the shopping center, retention ponds, 2 retention ponds, a creek, a cluster of trees, and Regents Park Drive. The normal route of travel from the front entrance of the proposed lounge to the community pool is approximately 1,200 feet. For the reasons above, staff finds that proposed wet zoning does not pose significant impacts on the surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances identified above. Therefore, staff finds the request approvable. Approval is based on the wet zone survey, indicating a total of 2,729 square feet of floor space for the proposed use that was received on May 9th, 2019. I'm here if you have any questions.
I don't, but thank you so much. Is there anyone here that would like to speak in favor of the application? Anyone in support? Seeing no one. Anyone in opposition? No one. All right. Mr. Hisney, anything further?
No, ma'am.
Okay. Sir, do you have anything else to say? All right, thank you for your time and testimony. With that, we'll close special use 19-0581 and go to the next case.
Our next case is item C2. This is special use application 19-0777. The applicant is Timothy Powell. The request is for a 2 COPX alcoholic beverage permit that requires distance separation waivers. Staff report and recommendation will be presented by Annie Barnes.
All right, is the applicant here? Good evening.
Good evening. My name is David Wright of TSP Companies. My address is P.O. Box 1016, Tampa, Florida, 33601. I am the authorized agent for this application, and I have been sworn in. I'm requesting a special use for a 2 COPX alcoholic beverage permit for a portion of the property located at the southwest corner of U.S. Highway 301 and Cone Grove Road in Riverview, Florida. The Board of County Commissioners approved a planned development zoning of the subject property March 12, 2019 under application number RZ-18-1363. The PD zoning permits the development and operation of a commercial athletic facility including up to 6 small-scale soccer fields, 3 volleyball courts, and a concession building. The athletic facility will be targeted to adults and will provide a venue for soccer and volleyball leagues. This request for a 2 COPX alcoholic beverage permit is to allow the business to serve beer and wine to its customers for on-site consumption after they participate in athletic events in the facility. Per LDC Section 6.11.11D, the proposed 2 COPX wet zoning must be located at least 500 feet from specified community uses and 150 feet from residentially zoned properties. This special use application includes a request for 3 waivers as allowed under LDC Section 6.11.11E. The first, I'm requesting a 480-foot distance waiver from the Learning Station Daycare. The significant mitigating elements of the soccer fields, landscape buffer, and 8-foot tall fence mitigate the negative impacts of the requested permitted use to the community use. Additionally, no vehicular or pedestrian access between the uses is proposed, and the physical route connecting the requested permitted use to the residentially zoned the community use is 718 feet. We met with the owners and operators of the Learning Station Daycare the evening of May 21st to discuss their concerns related to this request. The discussion that occurred during that meeting resulted in the letter of support for this application submitted by the Learning Station that is included in the party of record, and I've also provided a copy to you tonight. Number 2, I'm requesting a 118-foot distance waiver from Mercy Church Ministries. Highway 301 is a 6-lane divided highway located between the requested permitted use and the community use, which provides a substantial physical barrier without a signalized intersection or crosswalk as a significant mitigating circumstance. It is also noted that there is an existing 2 COP permit located within the same shopping center where the church is located, and the distance separation between the church and that 2 COP permit is approximately 30 feet. This community use was sent a notice of the request as required, and we were not contacted by any representatives of the community use. And third, lastly, I'm requesting an 84-foot distance waiver from the residentially zoned property. The significant mitigating elements of the soccer field, stormwater management pond, landscape buffer, and 8-foot fence mitigate the negative impacts of the requested permitted use to the residentially zoned property. Additionally, no vehicular or pedestrian access between the uses is proposed, and the physical route connecting the requested permitted use to the residentially zoned property is approximately 850 feet. The property owners of the residentially zoned property also submitted a letter of support for this request, and it is included in your package. I would like to thank the Development Services staff for working with me on this application. Staff evaluated the application, including the requested waivers, and found the proposed wet zoning does not pose significant impacts on surrounding land uses. The necessity for the specified distance separation requirements is negated by the circumstances identified by the applicant, and the request to be approvable. No objections were received from any reviewing agencies. I noticed the surrounding property owners, neighborhood associations, and distance waivers as uses as required. I was not contacted by any citizens other than the owners of the Learning Station and the Miltoners, who both submitted letters of support. We have not received any objections to this request, neither are any objections listed in the party of record. We agree to the conditions of approval as listed in the Development Services staff report, and based on the submitted competent substantial testimony, the evidence in the zoning file, and that is part of the public record and the evidence being presented tonight, I respectfully request your approval of SU 190777, subject to the conditions of approval, and I am my client, the Welshes, are here to answer any questions.
I just have a quick one to ask if you approached the church about the waiver request.
We just sent them the notice. We did not actually approach them.
And you didn't hear back from them?
No, we did not.
All right, thank you so much for your testimony. If you could sign in. Yep. Development Services, please. Good evening.
Good evening. Annie Barnes with Development Services, for the record. I'll try to be brief as well. SUAB 19077 is a distance separation waiver for a 2 COPX alcoholic beverage permit to allow for the sale and consumption of beer and wine on the premises in connection with the proposed commercial sports facility located at the southwest corner of US Highway 301 South and Cone Grove Road. As shown on the wet zone survey, the proposed wet zone footprint will comprise of approximately 18,000 square feet in the center of the site, where the facility's concession stand and patio area will be located. Per the LDC, proposed 2 COPX wet zonings must be located at least 500 feet from community uses and 150 feet from residentially zoned properties. Per the submitted survey, Stacy's Learning Station and Child Care Center, a community use, is located 20 feet from the proposed wet zoning, requiring a 480-foot waiver. Mercy Church Ministries, another community use, is located 382 feet from the proposed wet zoning, requiring a 118-foot waiver. And additionally, a residentially zoned property at 10609 Cone Grove Road is located 166 feet from the wet zoning, requiring an 84-foot waiver.
Could I interrupt you just
Yes.
to not leave that point? I just had to clarify your staff report.
Yes.
It says in the 4th paragraph down in your staff report, it says that the residence is located 166 feet, but
Yes.
the requirement is 150 feet
Oh,
away?
I apologize.
Is it 250? Is that the?
It'll be 150 feet. And let me look at the survey real quick. I just located.
Madam Master, no, the requirement, that's a typo. The requirement is a 250-foot separation from
apologize.
residential
Okay.
property.
All right, so the request for the waiver, the 84 feet is correct. It's just the
Correct.
it's 250
Yes,
instead of
ma'am.
1.
I apologize.
Go ahead, I'm sorry, go ahead.
No. Staff concurs with the applicant's justifications for the distance separation waivers from both community uses and the residentially zoned property as outlined in the staff report. A letter of support from the owner of the child care center has been submitted into the record, and a letter of support from the residential property owners located at 10609 Cone Grove Road has been submitted into the record. For these reasons, staff finds that the proposed wet zoning does not pose significant impacts on the surrounding land uses and finds the request to be approvable, subject to the following conditions. 1, the sale and/or consumption of alcoholic beverages shall occur only within the approved wet zoned area. However, the consumption of alcoholic beverages shall be prohibited on any portion of the playfields or parking lot which may be located within the wet zoned area. 2, the facility operator shall post and maintain a conspicuous sign on the concession stand stating that alcoholic beverages are not allowed outside the concession area and patio. And 3, the sale and/or consumption of alcoholic beverages shall be limited to Monday through Saturday from 8 to 11 p.m. and Sunday 11 a.m. to 11 p.m. And that concludes my report.
All right, thank you so much. I didn't have any further questions. Is there anyone that would like to speak in favor of this application? Anyone in support? Seeing no one, anyone in opposition? No one. Mr. Hisney, anything further?
No, ma'am.
Okay. The applicant? Anything else? All right, thank you for your time and testimony. We will close SUAB 19-0777 and go to the last special use case.
Yes, our last special use tonight is item C3. It's application number 19-0822. The applicant is Jacob T. Kramer. The request is a special use permit for a community residential home. This request also includes a variance to encroach into the required 30-foot setback from a wetland conservation area. Staff report and recommendation will be presented by Colleen Marshall.
Good evening.
Thank you. Good evening. Jake Kramer with Stearns Weaver Miller, 401 East Jackson Street. I'm going to move to Elmo.
Okay.
Thank you again. I'm here representing Rob and Nancy Loomis tonight. They run a Country Place, which is a community residential home type C. It's 24 beds, and that was originally approved in 2005. It's been an ALF going back in history, historically longer than that. So we're here tonight asking for one additional bed for the special use, as well as an accessory detached caretaker's cottage. We're asking for the same separation waiver reduction that was approved in 2005 originally. Staff agrees with us that the one additional bed will not make a material difference in the separation waiver because the structures will still look as if they're residential facilities from the outside. We also have significant tree coverage on the site, as well as required buffering under the code. As for the caretaker's residence,
Mr. Kramer, if you could zoom out a little bit. Allison, if you can help, needs to. There you go, perfect. Thank you.
this is the wetland site plan that was submitted as a part of our variance, the variance portion of our application. Got it. Okay, thank you. The caretaker's cottage is only going to be for a caretaker. The 25 beds are all going to be located in the existing facility. The caretaker's cottage, we had several several constraints that we were dealing with and trying to figure out where to site it. Just to help you get your bearings, this is the caretaker's cottage. This is the existing facility, and there's several small existing structures. There's existing parking in the front, and there's proposed additional parking here. In blue are the setbacks, along with the wetland setback. So we were, the site is covered by over 40% wetland and wetland setback area, and so when you combine that with the side yard setbacks, we were limited in where we could site the cottage. As you can see, there are a lot of existing trees on the site, and we were working to try to save as many of those as possible. Part of the idea of this facility is to have a natural environment for the residents. There's a small farm on the site, and this is where they live. So we're trying to preserve as many of those trees as possible. So we also looked at siting potentially here or here, and this is sort of the Goldilocks principle, because the caretaker's cottage can't be too far away from the main structure, because its purpose is to have a caretaker who's watching the facility, and they need a line of sight to be able to see the facility at all times. The reason why it can't be too close to the facility is you get into fire code issues of having a residential structure too close to essentially a commercial structure. And so when we worked through those constraints with the engineer, this was the preferred location for the cottage. And the encroachment is essentially the porch and areas for exiting the cottage. So we worked with staff. We didn't need to, under the code, necessarily mitigate for the impact, but we are, and we're essentially over mitigating with plants that are larger than we would need to otherwise. We have our engineer, our wetland scientist, and my client here. If you have any questions about the operation or anything else, we're happy to answer those.
Well, you you partially addressed my question as to why there as opposed to other places for the wetland encroachment. So it's extending how many feet into that wetland setback?
It's 14.6 feet.
All right, but
into the wetland setback.
obviously not into the actual wetland, just the conservation area setback?
That's correct. No impacts to the wetland.
Okay. And how, if you know, how large is the house, the cottage?
It's just under 2,000 square feet.
Okay. And the encroachment you testified was primarily a porch?
Yes, ma'am.
Okay. That was the extent of my questions. Thank you very much.
Thank you.
Development Services, please. Good evening.
Good evening. Colleen Marshall, Development Services. The applicant stated the request is for a special use permit for a community residential home type C with a maximum of 25 residents in a detached caretaker's residence. The community residential home was originally approved by SU 05-0119 for 24 residents. LDC Section 611-28A requires a community residential home type C to be located a minimum of 500 feet from areas of non-agricultural single-family zoning. The applicant's requesting a waiver of this requirement to allow a separation of 90 feet from PD zone single-family property to the east and 200 feet from PD zone single-family property to the south. The existing community residential home is residential in appearance, and the proposed caretaker's residence will not be visible from any property lines given the existing trees and screening and the location on the 5-acre parcel. Additionally, the home takes access on Memorial Highway external to the residential neighborhoods. Given these considerations, staff does not object to the proposed separation waiver. Per LDC Section 4.0107B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of the residential structure within the 30-foot wetland setback. The applicant requests a 14.61-foot reduction of the setback to allow a setback of 15.39 feet. And a separate decision on the wetland setback variance will be required in conjunction with the special use permit.
Let me stop you and ask you a question.
Yes.
That was my question about this,
Yes.
this staff report. So when you say, first of all, it's appropriate in the county's opinion to have this variance request considered through the special use process?
Yes.
Okay. And when you say separate decision, you mean just a separate finding to pull those two requests, the special use for the actual community residential home, and then separately address the encroachment of the cottage?
Correct.
Okay. That's it. Go ahead, please.
So no agency objections were received by staff, and staff recommends approval. I'll be happy to answer any questions.
That was it. Thank you so much. All right. Planning Commission, please.
Melissa Leinhard, Planning Commission staff. The subject property is located within the Residential 6 future land use category. It is in the urban service area, and it is also located within the limits of the Town and Country Community Plan and the Northwest Hillsborough Community Plan. The additional requested density reflects what can be considered within the Residential 6 future land use category for all of the residential options. As this use currently exists in the community, the increase in the number of beds from 24 to 25 does not create any new impacts on the surrounding property and is of similar scale to the development pattern within the area. Residential support uses are encouraged to be located in residential areas to support the neighborhood residential population. The special use request for the expansion of the community residential home with an additional 1,945 square feet bungalow would be comparable to the surrounding development pattern, as residential uses are located east, south, and north of the subject site. The special use request is also consistent with the Northwest Hillsborough and the Town and Country Community Plans. The Town and Country Community Plan encourages the renovation and retrofitting of residences, while the Northwest Hillsborough Community Plan encourages alternative community development patterns that allow the independence for the elderly and the young. Based upon those considerations, Planning Commission staff finds the proposed special use consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services.
All right. Thank you so much. We'll call for anyone that would like to speak in favor. Anyone in support? Seeing no one. Anyone in opposition to the request? All right. No one. Mr. Hisney, anything further?
No, ma'am.
Mr. Kramer?
I just wanted to add that my client did speak with many of the neighbors personally, and there are several letters from residents in support in the record.
All right. Thank you for that testimony. I appreciate it. With that, we'll close special use 19-0822. I think it's a good time to take a 5-minute break before we start the zoning section. So by the back of the clock, if you could be back at 8:30, we'll reconvene. Thank you.